Assalamualaikum warahmatullahi wabarakatuh. My name is Khoiruttamam. I am from class of English for Academic Purposes 7A. I will present about international law in the prevention and control of the crime of human trafficking. Definition of the crime of human trafficking. The crime of human trafficking in Article 1 of Law number 21 of 2007 concerning the eradication of the crime of human trafficking. Human trafficking is the act of recruiting, transporting, harboring, sending, transferring, or receiving a person by means of threats of violence, use of force, kidnapping, confinement, forgery, fraud, abuse of power, or a position of vulnerability, entrapment debts, or giving payment or benefit, so as to obtain the consent of the person who has control over the other person, whether carried out within countries or between countries for the purpose of exploitation or causing people to be exploited. Forms of human trafficking. The modus operandi of the criminal act of human trafficking that often occurs is recruiting prospective female workers aged 70 to 25 years, promise to work in restaurant, beauty salon, hotel employees, factories with high salaries, falsified identity, administration, transportation, and accommodation fees were cheated by the agent. Without any calling visa or working permit or using a short stay visa. Network outages and victims are sold, held captive, and employed as prostitutes. International law governing the crime of human trafficking. The establishment of the Palermo Protocol encourages each state party to this convention to take legislative and other measures deemed necessary to prevent, crack down on, and punish human trafficking, especially women and children. The Palermo Protocol of 2000 concerning preventing, eradication, and punishing the criminal act of human trafficking. Punishment for the perpetrators of the crime of human trafficking, seen in the regulation issued by the United Nations, which were ratified by the State of Indonesia in the form of Law number 21 of 2007, which in this rule regulates sanction against people who have committed crime. The crime of human trafficking, the sanction contained in the ratification in the national rule, can be applied to the perpetrators of the crime of human trafficking only to countries that receive trafficking and are returned to the country of origin of the victim. The criminal code has formulated a criminal threat of a maximum of 6 years for perpetrators of crime who have carried out the crime of human trafficking, in which women, children, and men are adult and who are not yet old enough. International cooperation efforts in combating the crime of human trafficking. Cooperation in eradication the crime of human trafficking can be in various ways, namely by making an agreement between countries so that if there is an act of human trafficking from one country to another country that makes an agreement, it can be followed up more quickly and efficiently in prosecution and termination. Indonesia has collaborated with other countries, for example, cooperation with Malaysia. Because there are so many victims, The target area is Malaysia. The obstacle faced in combating human trafficking. 1. Differences in perception with the public prosecutor made P19 several times. This is related to the evidence that are required to fulfill the element in the crime of human trafficking law, because they have to be studied all the way to Malaysia. 2. Law number 18 of 2017 concerning Indonesian migrant workers can be used in conjunction with the crime of human trafficking law. And 3. The competence of the immigration or PPNS has done so, and this has led to overlapping with Polri investigation. That is all from me. Sorry if there are mistakes in the pronunciation. Wassalamualaikum warahmatullahi wabarakatuh.